Hello, and welcome to another live Q&A here at immigrationquestion.com. Excited to be here. Our topic today is to answer questions on exploring alternatives to the waiver for unlawful presence, overcoming the 3-year and 10-year bars. My name is Andy, and today we'll be focusing on just what I said. Facing a bar, whether 3 or 10 years after a visa denial, can feel pretty devastating for people, and knowing the right things to do to make it just a roadblock and not the end of your immigration journey is important. In today's live Q&A, we'll explore alternative legal pathways to reentry and offer strategies and tips to overcome these bans. Joining us to break down these complex issues is a seasoned attorney, a very accomplished immigration attorney based out of San Juan and Tampa, Florida. And everybody take a second to welcome Michelle Reyes.
Thank you so much.
So you have a lot of legal experience in a few different areas, including
Yes.
immigration law. And you have offices, you keep offices in Tampa and San Juan as well.
Correct.
Can you tell me kind of your experience with the bans being, the 10-year and the 3-year bar?
Yeah, so first, I'll just explain a little bit about myself. So I am a licensed attorney. I'm licensed in Florida and Puerto Rico in both federal and state courts. My background, I've worked a lot of family cases, criminal defense cases, litigation cases. So I bring that knowledge into immigration. Sometimes they cross over. So it's really important to understand those practice areas also. And now we are mainly focusing on immigration because it's my passion, it's what I love. And that my experience helps with the cases that I work on now. I studied law in New York. And so as we know, there are many immigrants in New York. New York is a diverse melting pot, if you'd like to call it that. And while I was studying law, I worked on criminal defense as well as special immigrant juvenile cases. So now what I like to focus on within my practice of immigration is helping undocumented immigrants that have either accumulated unlawful presence or have inadmissibility bars. And there are ways that people can obtain their residency, obtain legal status in the US that is an alternative to the waiver that we all know. So if you'd like, I can explain a little bit about the bars and then go into the alternatives.
I'm sorry, I don't know what's happening with that. Apologies for that brief interruption. Yeah, I would love for you to expound on that. That'd be great. Thank you.
Okay, sure. So there are different kinds of bars. There's the 3-year bar, the 10-year bar, and the permanent bar. The 3-year bar is when one enters one time and has an unlawful presence, right, where either a visa expired and they have been in the US for less than 1 year. And the 10-year bar is when they have been in the US for more than 1 year. And the permanent bar is when they have had more than one entry, or let's say they had a removal order and they returned again without permission. So normally with the bars, you have to ask for a waiver. If you get married, for example, let's say you have a bar, you have an unlawful presence bar, and you get married. So now you have a way to adjust your status, become a resident, but you have this bar. So you need to ask for a waiver, or a pardon. In Spanish, we call it el perdón, which is kind of like asking for forgiveness so that you can then become a resident. But even then, with the waiver, you still have to obtain your residency abroad, right? You have to go to a consular post in your country so that you can obtain your residency. And this can be cumbersome. A lot of people are afraid, of course, very understandably, of having to go outside of the country and adjust their status, which is what it's called when you are obtaining residency, is adjusting your status from non-immigrant to a permanent resident, right? So instead of having to go outside of the country, perhaps risking not being able to come back in, right? Even if you have a waiver, there could be something that happens at the consulate where you're not able to come back in for whatever reason. They don't approve it, or you don't know how long it's going to take. So it's a risk no matter what, right? When you have to adjust your status outside of the country in a consulate. So a lot of people want to avoid that. And not only that, some people, if they leave, they're subject to the 10-year or permanent bar. And if they're not able to get the waiver, then they have to wait outside of the country for 10 years. In the instance of a permanent bar, they would have to ask for permission before asking for a waiver, and then see if they can come back. So this can obviously affect families, because if you're getting married and trying to come back in, then you'd have to be, either your spouse has to go with you, or you're going to be separate from your family for 10 years. So it's not always the best case scenario. Some people have permanent bars because they have multiple entries, right? And once that is the case, there's no going back, except for, like I said, waiting outside 10 years, proving that you were outside for 10 years, and then asking for that waiver, asking to apply for the waiver and asking for the waiver. And then once it's approved, coming back. And the waiver can also take a long time to get approved, sometimes years. So it's a very cumbersome, long process. It affects families, like I said, they're not able to stay united. Someone has to disrupt their life and leave the country. But there are alternatives to that. A lot of people I have found are not aware that there are alternatives, and that's what I wanted to talk about today.
Great. Most people think that a waiver is the only option after a visa denial. Why might a waiver not be the best solution in some of these cases?
It's not the best solution because sometimes, like I said, if they have a permanent bar or if they have a 10-year bar, they'd have to be separate from their families, and they'd have to adjust their status and obtain their residency outside of the country, in their own country. And staying outside for 10 years, in their own country might not be the best case scenario. They're going to miss out on their children's upbringing, or their children might have to be uprooted if they decide to take them. So it's a very difficult process. And then once they apply for the waiver, it can take a couple of years, 2, 3, up to 5 years. So it's just, a lot of people opt to not go through that. And unfortunately, that ends up, with the person being undocumented in the US and living in the shadows, versus going through the waiver process, because it's so long and drawn out, and it's not certain either. So fortunately, there are some alternatives. They don't apply to everyone, but they do apply in some situations, and people that are not aware of them, it's good for them to know that they might qualify for one of these alternatives if they become educated about what they are. So the first one, sorry, I'm out of breath. I'm almost 6 months pregnant, so I get out of breath. Yeah. So the first alternative is called the T visa. And this is a trafficking visa. And the T visa is for people that have been victims of either labor exploitation in the form of labor trafficking or sex trafficking. And sometimes when we think about trafficking, we think about what we see in the movies, right? Or what we hear, let's say, P. Diddy's situation recently, where very extreme situations, and that absolutely does qualify. But there are other situations that are not as extreme that do qualify, and that can become almost like a common day situation. But then people don't know there's a relief or a protection for them. So this would be, for example, the person that had a job, and at that job, because they were undocumented, their manager, the owner of the business, whoever their boss, knew that they were undocumented. So they forced them to work long hours. They forced them to work, 10, 15 hours per day, anything that's more than what's legally acceptable, right? 40 hours per week. They didn't pay them overtime. Maybe they paid them less. Maybe they paid them less than minimum wage even, or didn't even pay them. And they held over their head, you're undocumented, so you have to accept this. So that is a form of labor trafficking, where there is force, fraud, coercion, and they're forcing this person to work in an exploitation scenario just because they're undocumented. That's one, right? And then there is the sexual trafficking, which is where someone forces someone to do something in a sexual act, or in exchange for either their freedom, their liberty, or even for a job. Like, you have to do this because you're undocumented. Let's say a manager forces the employee to do something because you're undocumented, so you have to have a relation with me if you want to keep your job, or if you want to get paid. So that's the sexual trafficking right side of it. And it's the same thing. They're using force, fraud, coercion. That trafficker knew what they were doing. They had the intent of taking advantage of this person because they're undocumented, and that person, because of the power struggle, really felt like they had no way of escaping that situation. They had to accept it because, in their mind, they're undocumented. They have no way to get out. They have to accept whatever the situation is.
Okay.
And then the third element with the T visa is that they would experience extreme hardship if they were to return to their country. That can be shown with a lot of times with country conditions, or if they have family in the US, that they would have to leave if they had to return. And let's say their country is in a bad situation, which unfortunately a lot of Latin American countries are right now. They're in turmoil, whether it's economic or political, or criminal turmoil situations, whatever, with gang-related violence. So they would suffer some sort of hardship if they had to return. And lastly, that T visa applicant has to report the incident. So they can report it either to a law enforcement agency. It can be police, it can be the FBI, it can be the Department of Labor. It doesn't have to be a criminal investigation agency. It can be a civil investigation as well. Like I said, the Department of Labor. It can be the the EEOC for discrimination. As long as they report and they participate in the investigation and they collaborate, if required of them, then they should qualify for the T visa.
Great, thank you. I really appreciate that. Is there any other legal pathways besides the visas that you
Yes.
just explained to overcome the 3 or 10-year bans?
Yes, so that's one is the T visa, right? And so with the T visa, you can apply for a waiver of inadmissibility as well, including the unlawful presence. So they don't have to leave and they can do the whole process within the US. So that's the first one. The second one is the U visa. And the U visa is for victims of certain crimes. There's a list of crimes that USCIS identifies as qualifiable for the U visa. For example, kidnapping, domestic violence can be a U visa qualifying crime, felonious assault. It's a long list, and as long as someone is a victim of one of those crimes, there's a case, there has to be a case opened essentially in court. There's, a case, there's charges against the perpetrator, and then that victim participates in the investigation, in the prosecution, so that they can obtain a U visa certification from the prosecutor's office. Once they have that U visa certification, then they can apply for the U visa. And the same thing with that. They can apply for a waiver of inadmissibility or unlawful presence as well, and not have to leave the country, and they can adjust their status within the US. And there's one more. If you have any questions on the U visa, I don't know.
No, go ahead. We will have the Q&A, and if people have questions, then they'll ask in the question portion of the interview.
Okay. The last one is called VAWA, which is the Violence Against Women's Act. And that is for victims of domestic violence, can be men or women. And it's, it started as VAWA because that was essentially the purpose of the law initially, but of course it can be anyone that's a victim of domestic violence, I'm sorry. And the perpetrator, the abuser, is a resident or a citizen of the US, and the victim is an undocumented immigrant, right? It can also be someone that is here on a tourist visa and they got married. They do have to be married if it's a spousal domestic violence situation. And they can apply for themselves. Where otherwise, if they were in the US on a tourist visa, for example, they had lawful status but not permanent lawful status, but their spouse is abusing them and does not want to apply for the spousal petition, that person can then apply for themselves, whether, as an example, a tourist visa, but they can also be undocumented with an expired visa or have an unlawful entry into the US as well. So as long as they need some sort of permanent lawful status, they can apply for VAWA without the abuser knowing, which is really, really important. The same with the T visa, like they can apply for these without notifying the person that abused them, which is important for a lot of people. Sometimes they're afraid of speaking up or having to face their abuser. They kind of think it's something like on court where you have to stand on a witness stand and accuse their abuser, but that's not the case, thankfully. They stay confidential, they stay protected. And this also can apply for, it can also be for stepchildren of residents or citizens, or parents of residents or citizens as well. So if it's an undocumented parent, they have children that are 21 and above that are adults, and the parents have been abused, they can also apply for the VAWA. And the same thing, they can apply for themselves. They don't have to leave the country. And that's the great benefit with these three kinds of visas.
Awesome. I really appreciate that. And, thank you for your time so far. Just quick question, just my question. We'll get into the Q&A really quick. When applying for these exceptions to your ban, do you need to do that in the United States, or can you do that after the ban has been implemented? Let's say you had a removal or you were deported. Can you go to your consulate in another country and apply for these visas?
That's a really good question. So for the T visa, they do have to be physically present in the US. They can be, if they were outside of the US, they can be allowed back in if, an investigation requires them to come back in, and they can be given a visa to come back to the US. It's not as common, but it is possible. The same for the U visa. But usually the person is in the US. And that's a good question that you brought up, because they can even be in the US with a removal order, but they never left. Or they came back after a removal order. So these can pardon, those inadmissibility issues. A lot of issues that wouldn't be able to be waived any other way. So it's really fantastic. With the VAWA, they can also apply outside of the country as long as the abuse happened within the US.
Okay. Thank you very much. I appreciate that. We're now going to go into the live Q&A portion of the show.
Okay.
And we're going to take some answers from the audience. I wanted to take a second to let everybody know that if they do have a question for Michelle, who's been so generous with her time so far, to please type it into the chat, and when we will post it, we'll try to answer as many people's questions as possible. This is a question from Camille Eduardo. I have a child who is a US citizen. Can I apply for a waiver based on hardship of my child?
So it depends on a little bit more, right? Because if he's asking for a waiver of the 3-year or 10-year bar or the permanent bar, it depends on the bar. Sometimes people hear of what's called it's cancellation of removal, but what's known in the immigrant community as the 10-year law, essentially. And that's something completely different. And what that is if you are in removal proceedings, and I assume that's what he means, I don't know. He could mean just the waiver or the cancellation of removal. But the cancellation of removal is usually based on when there's hardship to family members. Then after being in the country for 10 years, they can apply for cancellation of removal. And the same thing for the waivers. You have to have a qualifying relative, which is actually not a child. It would have to be either a spouse or a parent to qualify for the waiver. So with the child, he would not qualify for the waiver if that's what he's asking for. Possibly cancellation of removal, but not for the waiver.
Okay, great. Thank you very much. We hope that answers your question, Camille. This is a question from Carlos. I was deported after being convicted of a misdemeanor. Can I still obtain a waiver?
That it depends on the crime as well. If it's a drug-related crime, much harder, especially if it's a drug that's not marijuana, even harder to obtain a waiver. Yeah, if it's cocaine related, there's almost no, very, very, very difficult, if anything, to be able to come back. So, I would explore, possibly some of these other alternatives, even if they're outside of the country. Perhaps at some point they were a victim in one of these type of cases, and they could see if maybe get a visa to come back through one of these visas.
Okay, great. Thank
Mhm.
you. Just a brief second, I want to remind everybody that you are streaming live. We're here with Michelle Reyes, who's in San Juan, Puerto Rico, and this is immigrationquestion.com. It is a platform where immigrants or people seeking immigration help can connect with attorneys who have answers. There's also an open forum where you can just have your questions answered by your peers who maybe have some insights from their own experiences. If you guys want more information, go to immigrationquestion.com and sign up. And likewise, if you are an attorney seeking to connect with people seeking immigration help, there is the same website, but you just sign up as an attorney and you'll get connected to people seeking immigration help and potential clients. Michelle, before I get into more questions, have you had a chance to look over immigrationquestion.com? Do you have any experience with the website?
I don't. I'm sorry. I saw some
That's
of the previous the previous sessions that you've had, but not the website per se.
okay. Well, you know what it is now, and thank you very much for joining
Mhm.
us. It's
No
just a
problem.
platform to connect people seeking immigration help. Let's get into one of our next questions, and this is from Maria Angelou. How long does it take to process a waiver application?
So, word on the street, because all of us attorneys are always comparing stories, war stories. Usually, it takes from 3 to 5 years, and that's what I've seen also, and that's what I've heard from other attorneys. Because these are agencies. They have their own timelines. Sometimes they take longer, sometimes they take shorter. Someone could be lucky and have a shorter time frame, but the average is about 2 to 5 years.
Okay, great.
Mhm.
Um, looks like we have a question in the chat that we could answer really quick. This is from Habib Salou. I hope I'm pronouncing that correctly, Habib. What options do I have if my green card application gets delayed or denied?
Delayed or denied, those are two different questions, but delayed, you can file like a mandamus and try to get it accelerated. It depends on how long it's been. If it's denied, it depends on the reasons why it was denied, honestly, and there could be many reasons. So it's kind of hard to answer that without more detail.
Yeah, Habib, I think that's a broader question. So if you want to seek a bigger answer to that, or connect with an attorney, go over to immigrationquestion.com and type that into our forum. You can sign up for free, and you'll be connected with a immigration law professional. Here's a question going back. I think that was off topic, kind of. So getting back on the
Mhm.
topic of bans, I'm still outside the U.S. Can I apply for a waiver?
You can apply for a waiver if you have waited the time that you're supposed to be, depends on what kind of what bar you have. If it's 3 or 10 year permanent bar, you can apply after the time that you're supposed to wait has passed. And if you have the permanent bar, then you have to also apply for permission to apply for the waiver at the same time.
Okay, great.
Mhm.
Thank you for that. Okay, we have a question from Anna Makedo. My U.S. citizen child is severely disabled and it requires my constant care. I was deported after overstaying my visa by 11 years. Can I qualify for a waiver based on extreme hardship?
Again, that depends. I mean, if they're in the US or outside of the US, it depends, right? And I'm sorry, I'm trying to see the question here. You said it was deported after overstaying my visa for 11 years. So she has, if that's her only entry, that would be a 10-year bar. So she would have to wait outside of the country for 10 years before applying for the waiver. But then again, her child is not a qualifying relative, so she couldn't apply for a waiver with her child.
Okay.
Mhm.
All right. Let's get another question up there. Thank you. And feel free to ask me again. I know that you are on your phone, so I know it's harder to read because
Yeah,
it's smaller time.
very small.
This is from Priya Mahir. And if my waiver application is denied, can I reapply?
You can reapply if you have different facts that would qualify. Based on the same exact facts, not, it would essentially be denied again, unless it's something time related. But if you have different facts, then you can reapply.
Okay, great.
Mhm.
Looks like we have time for a couple more questions. If people have questions, remember to type them into the chat, and I will try to get through as many of them as I can. This is a question from Olu. I've been in the US for 8 years. My US citizen spouse filed for me, but I was placed in removal proceedings. Can I still adjust
Mhm.
my status without leaving the country?
Yeah, well, it depends on why you're in removal proceedings and how you entered. If you entered without permission or parole, then you would have to apply for residency outside of the country. If you entered with a visa or admitted or paroled somehow, then you can apply within the country. But again, I don't know why you're in removal proceedings, so that could affect the answer as well.
Awesome. Thank you very much.
Mhm.
This is from Sakshi. I'm not going to try to pronounce your last name. I apologize. I have a
Mhm.
very Anglo ability of doing last names. So, Sakshi, how can someone overcome the unlawful presence bar without applying for a waiver?
So that would be considering one of the three options that I covered essentially, which would be the T visa, U visa, or VAWA, unless, for example, you are eligible for TPS, maybe for a temporary protected status. You could get an advanced parole and leave and come back, or DACA perhaps. Well, there's no new DACAs, but you would have to think if at any point were you exploited in a job situation where you were forced to do work um, because you're undocumented, or if you were a victim of a crime, or if you have a family member that is a resident or citizen that abused you in some way, then you could apply for VAWA.
Thank you so much. I hope that answers your question, Sakshi. And it looks like we have time for about one or two more questions. I'll look in the chat. I don't know. Okay, this is the last question. So I guess that is, oh, wait, this is our last question. So
Okay.
I really want to take a second to thank everybody for tuning in to this week's live Q&A. And I want to make an extra big thank you to Michelle Reyes for joining us from San Juan. You have offices again in San Juan and Tampa. And
Correct,
then
yes.
you can find her online to connect with her. It's Michelle Reyes, Reyes. And that's all for today. So thank you so much for joining us. I really appreciate that. And if you're new to us, this webinar is provided by immigrationquestion.com. And that was answering questions on alternatives to the waiver for unlawful presence, overcoming the 3 and 10-year bans. So visit our website, immigrationquestion.com, to connect with experienced immigration attorneys who can guide you through your unique situation. And if you missed any part of this session or would like to listen again, this is available on Spotify. The live stream is being recorded and it will be live for listening on Spotify. Simply search Borderless Talk by immigrationquestion.com and listen to today's sessions and previous ones to go. See you guys at our next session. We are live every Friday at 2:30 p.m. Eastern, and we'll have another seasoned attorney doing justice, speaking on the Understanding Non-Immigrant Visas, Essential Insights and Application Strategies. Wendy Barlow is the name of the attorney, and she'll be joining us next week to discuss further. So please put that in your calendars and join us next Friday. And until then, stay informed and empowered in your immigration journey, and have a great day. Thank you, Michelle. Have a great
Thank you.
fin de semana. And we really appreciate you being here. And thanks again.
Thanks, you too. Have a great afternoon and a great weekend.
Okay. Bye, Michelle.
Gracias. Bye-bye.